Okay, good evening everyone and welcome to our first online seminar for 2021. We may be back in lockdown, but it doesn't stop us running the seminars for you. Good to see you all. Hope you're all safe and well, and Happy New Year to everybody. For information, the seminar schedule for the first 4 months is now available on the website. Please feel free to view and book. We've got some new topics and some new series, Adjudication Matters, with Mohammed Haq, and we have obviously Construction Essentials, the first one of which is tonight with Richard Silver. Tonight, Richard will be covering contract formation and letters of intent. As always, if you've got any questions for Richard, please feel free to use the chat box or the Q&A panel in the bottom toolbar, and he will happily answer your questions at the end. If there's anything more specific or you don't wish to raise it in an open forum, you are also free to email Richard. His email address is on his contact details there, richardsilver@silverllp.com. So without any further ado, I will hand over to Richard.
Thank you, Julie. Happy New Year to you all. My name is Richard Silver. I am the Senior Partner of Silver Law. My background is in construction. I previously held the roles of Chief Surveyor and Construction Director before moving into the legal arena. I presently deal predominantly with disputes, either as a party representative or as the adjudicator, arbitrator, mediator. I'm on a number of panels, including the RICS and the CIArb. Giving the matter some thought over the Christmas period, I thought it might be useful to present a series of seminars on what I find are the major issues of dispute that ultimately lead to problems, be it through adjudication, arbitration, and litigation. And on that basis, I thought the first one we should deal with is contract formation and letters of intent. It is my view that this is the most important course of the 10 that I will be doing, and generally dictates which party is likely to be successful in any particular dispute. Now, you might find that somewhat surprising. I suppose one must start off and look at reality. And what I would ask is of the contracts you start on as, let's say, main contractor, how many of them actually have the contract signed and sealed before you start? It's my experience, it's not a lot. And quite often, contracts aren't signed until well into the construction process, and unfortunately on occasions, not until the job has actually been completed. And then if we look at the subcontracts and the consultants agreements, quite often they're in place, but actually how many of them are signed? Again, you know, loads of people come to me with disputes and they give me copies of the contract and they're not signed. And therefore, it's difficult to know whether they actually reflect whether or not that's what the parties have agreed. And it's this that we're going to deal with through the course, because ultimately, if you're going to determine who is responsible for a particular problem, be it defective work, late completion, one needs to determine what is the contract and what does that contract provide. Because if you can't do that, you will not be able to determine who is ultimately going to take responsibility. So let's start at the very beginning. What is actually the purpose of a contract? What's the difference between one type of contract and another? You will be aware of the JCT, the NEC, the ACA, the PPC, the ICAME, and I can go on and on and on. There's hundreds of them out there. Why have so many contracts? And I'm only talking about JCT as a suite of contracts. If we look at all the contracts within that suite, there's loads of them. So what's the difference? Why does one particular contract make a difference to another? And the important point to start is that what a contract does is it sets down procedure and risk. So I'm going to give you the standard one I go through. Exceptionally adverse weather conditions. It's a problem on construction projects. You are delayed, generally where there are external works, by the weather. And the question is, who is responsible for it? Well, the answer to most of my questions is always the same. It depends upon the contract. So for JCT, the exceptionally adverse weather conditions is considered a neutral event. It is an event which a contractor is entitled to an extension of time, but is not entitled to loss and expense. But if one looks at the NEC form of contract, it is a compensation event. And therefore, provided that contract has not been amended, the contractor will get both time and money. But if we look at certain of the GC Works forms of contract, you will actually see that it's not an event at all. So the contractor gets no extension of time and no loss and expense. So on the same basic facts, under one contract, the contractor can get extensions of time and additional money, and under another contract, they will get nothing. So what you need to understand is, what does a contract initially do? It allocates risk. Now, I'm sure it will not have escaped your attention that nearly every contract that is produced is either on the employing party's standard terms and conditions, or where a standard form is used, it is highly amended. And I'm sure it will be no surprise that where they are amended, it is to change the risk. Certain things in these contracts may well benefit the contractor. And if it's been amended, it is most likely that those amendments are increasing the risk, particularly on design and build forms, by creating a far more onerous obligation upon the contractor with regards to that design. So what I'm pointing towards is if you're going to deal with a lot of problems, you need to know what is the contract and what are those obligations. But equally, if you can get out of that contract, it may very much assist you. So what does a contract do? The first thing is to set down the risk. The second thing is it sets down procedure. It says what you should or should not do. And again, it is not uncommon for that contract to be amended. And one particular area which is often a problem is the issuing of notices and whether they are a condition precedent. In other words, whether you have an entitlement to extension of time or loss and expense, and whether it is conditional upon you having previously issued a particular notice within a particular time. Some contracts in their standard form, for example, the JCT, if not amended, does not make such notice condition precedents. But the NEC is quite different. Certain of the compensation events require the contractor to have issued an early warning notice and a compensation event notice. And if they fail to do so in the required time, may lose all entitlement. So we must look at this particular contract to establish what the terms are and what the obligations imposed on both parties are if we are going to resolve disputes. And the difficulty is that all too often there is uncertainty as to what is the contract. I cannot impress upon you enough. I have got out of so many contracts for my clients simply because they have not been signed and or agreed. And we're going to go through that process now. So, sure, most of you will be aware that in order to have a contract, you need to have 4 essential elements: an offer, an acceptance, consideration, and an intention to create legal relationships. So let's deal firstly with an offer. Fairly simple. In the main, it will be the submission of some form of tender, but it should be distinguished from what is an invitation to treat, which is in construction terms generally the invitation to tender. Now, the important point to raise here is quite often what the person asks in the invitation to tender is not complied with by the tenderer. For contractors, when you go out for invitation to tender to subcontractors, very often you will say, and these will be the terms that we will be seeking for you to agree to. But when you get the subcontract quotes back, they say quite the opposite. They have all their standard terms that are quite the opposite of what you wanted. It's not unusual in main contracts that when the employer goes out to tender, the contractor comes back with a whole list of things within the proposed form of contract that they do not agree with. Now, the point is, unless the invitation to treat is incorporated and express provisions are included, generally the invitation to tender is not relevant in determining what the contract is. Because what we need is an offer and an acceptance. We do not need an invitation to treat to form a contract. So what is the difference clearly in regards to an invitation to treat and an offer? Well, put simply, if you go into a shop and you see an item that is normally priced at £1,000, which has a penny on it, and you pick it up and say, I'll accept this, I'll buy it, you can't. Because in shops where things are up for sale, they are an invitation to treat. They are inviting you with the opportunity to buy it. And when you actually take that item up to the counter to pay for it, you are making the offer, and the person who accepts your money is creating the acceptance. I've got a case there, the Carlisle Carbolic Smoke Ball Company, which represents an exception. It's the original case, but you would have heard of some others more recently. One that got quite a lot of press is Hoover. What Hoover did was they made an offer saying, if you buy our Hoovers, we will give you 2 free flights with BA. And the problem was that someone obviously had poor mathematics, because roughly speaking, the Hoover cost £100 and the flights could be £3,000. So everybody bought their Hoovers and wanted the free flights. And to try and get out of it, Hoover said this was an offer to the world at large, and in other words, was an invitation to treat and was non-binding. The courts did not agree. Where you make an offer to the world at large, it is not an invitation to treat, it is an offer, and which can be binding once accepted. This is why whenever you hear on the radio or on the television, it says, please see our terms and conditions, so that they are seeking to incorporate those terms into the contract. So we've dealt with an offer. So the next question is if there is an offer, how long does that offer last? How long after it having been submitted can it be accepted? And the answer is that an offer is open for a reasonable period of time, unless the particular offer says it's open for a set period of time. So I make an offer to you, which I don't state any period within it for its acceptance, it will be open for a reasonable period of time. And depending upon the offer will dictate what is a reasonable period of time. But where it says it's open for 3 months, once the 3 months comes to an end, you can no longer accept it. However, where a tender is stated to be open for 3 months, doesn't mean it has to be left open for 3 months, because it is not a contract, it is purely an offer. And a party can withdraw an offer at any time prior to acceptance. Now, as I said, my background is in construction. And I used to be a site surveyor, and when we secured a new project, what would happen is the buyer would send a big box of files to me, and we included within that was all the tenders the buyer had obtained when seeking to produce his tender and which had ultimately been accepted. And my first task, ideally, was to go through all those tenders, obviously looking for further discount, but seeking to place the orders at the same price or less than that which was included within our tender. Now, what would occasionally happen was we'd included a very, very good price for a certain tender of works. I'd then go to the subcontractor and seek to accept it, and they'd say, sorry, we've withdrawn it. We've noticed a mistake and we're not going to stand by it. And I'd get into big arguments, but it says open for 3 months and the 3 months hasn't elapsed. Well, the simple rule is a party can withdraw it at any time prior to acceptance. So if you want to keep those tenders open, the only way of doing it is to actually make the tender a contractual obligation. And that would be easy. You could say, for example, we ask you to submit a tender, and that tender shall be open for 3 months, and you shall not be entitled to withdraw it. And for this, we will pay you £1. Because as we can deal with in a moment, you have to have some consideration. And your consideration is the £1 that they will not withdraw it. So that's the answer to get over that problem. So we're going to deal with acceptance in a moment, but where we have an offer, if a counter offer is made, this counter offer effectively displaces the previous offer, and the previous offer, can no longer be accepted. So I have, for example, a tender submitted by a subcontractor, and the subcontractor has said their terms and conditions are to apply, and I send out a subcontract order saying I agree your tender, subject to my terms and conditions. I've not accepted. I've made a counter offer, and that other tender, that original offer, is now rejected. If the subcontractor comes back and says, I'm sorry, I'm not willing to agree to your terms, so I say, okay, I'll agree to your previous tender, they can say, well, I'm sorry, that tender is no longer available. You've rejected it. So that's a very important rule. It's called the fighting of the forms. It is a common battling of the forms. It is a common problem on construction projects. Everybody sees subcontract orders, but they're not subcontract orders. They are nearly always counter offers. And therefore, what we need to do is to establish whether they have been accepted. So do be mindful of this. We need to have a clear acceptance. It must exactly fit the offer. If there is anything in the subcontract order that is different to what is the offer, and it is a substantial point, then it is likely not to constitute an acceptance. Moving on now to acceptance. Acceptance can take 3 forms: written, oral, and conduct. Written is easy. The subcontract can be signed and we can see it's been agreed because there it is, it's been signed in agreement. We can have an exchange of correspondence and we can look through that correspondence and see what the parties have agreed. Orally, just as binding, but a bit more difficult to prove. It is my experience that unfortunately, not everybody tells the truth. And some people will swear that black is white. They will deny that they ever agreed things. The amount of adjudications that come before me where both parties say the complete opposite with written statements and promises and everything. Whether one is lying or whether they simply have a difference of a view, I will leave that to you to determine. But it is much more difficult when you're seeking to rely on oral acceptance. Now, the final one is conduct. And what we're looking for is for something that indicates that a party has accepted the offer. Now, quite often people will say, oh yeah, I've got a subcontract order. I know the subcontractor hasn't signed it, but they're on site. They're working. We paid them. There's a contract. Must be, obviously. Is that right? If you've got a contract and it's unsigned, if you're looking for acceptance by conduct, what you must look for is that the acceptance must have followed the offer. You can't accept something until you've received the offer. So if you've sent out the subcontract order after they've started on site, you can't rely upon their starting on site as acceptance of something that hasn't been offered. So starting on site can be the acceptance of an offer made before. And indeed, allowing a party to start on site could be your acceptance of their tender. I do remember a subcontractor that no longer with us when I was in construction, who would receive a subcontract order but refuse to sign it. But he would come to site 8 o'clock before starting work and issue to the site agent a letter. And then he would start work. You would then open the letter and it said, I confirm my quotation to you for this. And by you allowing them to start, you'd accepted. No surprise, people don't employ them anymore. But what you need to understand is, so far as conduct is concerned, what we're looking for is something that after the offer has been made constitutes acceptance. And do be mindful that if there has been a counter offer, you can't accept something. So if someone has submitted a subcontract order and the other party has come back and said, I don't agree with this, I propose the following, but then starts on site, they cannot possibly have accepted your order because they've rejected it. And that's what we're looking in the battling of the forms. What is the agreement that's been reached? What was the last offer and what constitutes acceptance? Now, it may be, for example, that it was starting on site or allowing the parties to start on site. But equally, it could be you relying upon certain of the provisions of the contract. For example, if you've got a JCT contract and you start spouting out relevant event clause numbers, you may, by your conduct, have accepted that contract. So do be aware. I have had to spend considerable time in seeking to establish what the contract is, which neatly brings me to this slide, because you can only have a contract, something that is enforceable, if we know what we're seeking to enforce. If the contract is so uncertain, then you can't enforce something that no one understands. Now, certain implied terms can jump in to assist us in certain circumstances. If I place an order for you to wash my car, but I don't agree a price, you're entitled to a reasonable amount. If we fail to state how long you've got, you have a reasonable period of time. So these things can be established even if they're not expressly stated. But one thing that cannot be established by case law, and the case law I was referring to is the wagon mound, is what you're actually down to do. You can't enforce something if you don't know what it is that either party was down to do. So if I don't know the work I'm giving you, there cannot be an enforceable contract of something that is uncertain. The last one, well, we've got consideration and then intention to create legal relations. Just on intention to create legal relations, this is simply to deal with the situation where friends or relatives enter into agreements. Where friends and relatives enter into agreements, it's generally considered to be a social arrangement and hence quite often unenforceable. Clearly in construction, that is unlikely to occur. Moving to consideration, one of my favourite statements, consideration must be sufficient but need not be adequate. Doesn't seem to make sense. Well, it is my view in my cynical mind that the person who wins any invitation to tender, any contract, is generally the person who has underpriced the job. My experience says that in the main, the lowest tender is normally the one who is accepted, and they've generally underpriced the job. Now, let's just say they've woefully underpriced the job. Can they get out of it? No, they can't, because once there is a contract, that contract is binding. And what we must have is consideration. Now, the fact that I may only be paying you £1 for something that's worth £1 million is irrelevant, because the consideration is sufficient. It might not be adequate, but it is sufficient. And for a contract, it has been said that a peppercorn is sufficient consideration. You will be aware that quite often deeds are entered into by writing off across the face of a stamp, because the stamp has value, and therefore that is shown as the consideration. You will often see it saying for a payment of £1. That is because that is consideration. It is binding even if the consideration is insufficient. And it is my experience too often on construction projects, people have underpriced the works. Hard luck. So consideration must be something of value, but it doesn't necessarily have to be financial. So in any construction project, what is the general situation is that the contractor has an obligation to carry out the work, so they are providing consideration, and there is another party who is paying for that consideration, an amount of money, thereby creating a contract. But what if it is an existing obligation? Or where it's an obligation not to walk off site or not to take legal action? Well, in certain circumstances, these can be consideration. But let's give an example. What about the situation where a subcontractor says, I'm not doing any more of this work, I'm walking off site. And you say, but I've got a contract. You're obliged to do it. Well, I might be obliged to do it, but I don't care. I'm walking off site. If you then agree to pay them extra money to do that, it is unlikely to be enforceable, even though you may have paid the money, because that agreement is created through duress. And as a consequence, it is likely to be unenforceable because there has been a complete failure of consideration. Because what has the subcontractor provided? Nothing. They were obliged to carry out the work, and that's what they're doing. There has been no change. So in order for there to be a contract or an agreement, because do remember quite often it's an agreement after the contract, you're going to pay them extra money or it's a final account, you need to show there has been some consideration. Now, for example, paying a day early would be consideration. You're owed £5,000, I'll pay you £2,000, but I'll pay it today rather than tomorrow to help you out. That would be binding. But if I only agreed to pay you tomorrow and I was obliged to pay you tomorrow in any event, then there's a lack of consideration. Example of another form of consideration. I'm going to take you to adjudication. Well, look, I'll pay you some more money. Okay. Provided it was my honest intention to go to adjudication, if you didn't agree to more, that will be good consideration. This case is quite an interesting one. I've given you quite a lot of information in the notes. What it shows, and it's not unusual, sorry, it's this one, is that on construction projects, quite often I've found that progress is a problem and things are not going maybe as quickly as you would have liked. And therefore, what happens is you seek to negotiate with the subcontractor to do something more. And you say to them, if you achieve this or achieve that, I'll pay you a bonus. Now, it may be what you're agreeing to is just for them to do what was their original contractual obligation. And therefore, the question is are they getting something for nothing? But if the other party can show that by their actions, they have done something new, they've given new consideration, it will be binding. Now, under most contracts, we have a completion date. And if that completion date is not met, there's a liability for potential damages. What that shows is a party has a right to complete late. They don't have to complete by the completion date, because if they don't, you can levy damages. So if as a consequence you are, even where it's their own delay, you enter into an acceleration agreement where they look to complete by the original completion date, that is likely to be binding because they have provided consideration in that they've agreed to complete by the completion date, even though they were entitled to complete late, but be liable to liquidated damages. So we've covered a lot of information there. And what I want to do is to try and summarize the situation. It is very nice and easy if we have a contract and it's signed by both parties. And provided we know all the documents that are incorporated and provided there is no conflicts, then we should be able to determine exactly what the parties entered into and what their respective risks are. But where either the contract has not been signed or where there is a letter of intent, the situation can be far less clear. Where there has been a contract issued but not signed, we are likely to be looking for acceptance by consideration. Acceptance by conduct. And what we need to look at is, okay, number one, when was the contract sent? Tick box, we know that. Okay, what are we saying is the acceptance? Starting on site. Okay, tick that. Has there been, well, first of all, was the starting on site post the issue of the contract? Because if it wasn't, you can't accept something that hasn't been issued. If the contract was issued prior to starting on site, the next question is has there been any counteroffer issued between the issue of the contract and the starting on site? If there has, is that a counteroffer? And has that counteroffer been accepted by the employing party, allowing the contractor to start on site? So what we're looking for is offer and acceptance. If there's simply a rejection of the contract, but nevertheless the parties started on site, there is no clear offer and there is no clear acceptance. And hence there is no contract. And it happens a lot more times than you might imagine. What then we will need to look at is, following the issue of whatever is subsequently seen to be an offer, be it a contract that's suddenly issued, has the party done something to accept it? Silence won't be enough. Carrying out the works won't be enough, because they were carrying out the works before the order and they were carrying out the works after the order. They haven't changed, they've done nothing else. So it is not uncommon, surprising as you might think, to find that people are working on site with no contract. So if they're working on site with no contract, why are they there and what are the parties' obligations? We're going to address that as part of the topic of letters of intent. So what is a letter of intent? In my experience, these are the nature of terms included in a letter of intent. More often, the letter of intent starts with, it is our intention to enter into contract sometime in the future. So the letter initially gives an indication that it is not a contract, because the contract is going to be entered into sometime in the future, not now. But having said that it's our intention to enter into a contract in the future, it then says, but we would like you to start on site. But it usually has a cap. It might well say, for example, please proceed with the carrying out of the works up to £50,000, whereas the tender as submitted was £1 million. So clearly it's not an acceptance. It might say, please carry out the initial enabling works. But the tender was for the whole of the work. So again, it cannot be an acceptance because it is only limiting the work. It might say, please carry out the works up to the end of March, whereas the original contract duration was going to be another year thereafter. So again, it cannot be an acceptance. Quite often, the letter of intent also states that there are matters still to be agreed. For example, the terms of the future contract. We're still yet to agree on the completion date, the value of the works, the scope of the works, the terms of the contract itself, the design obligation. It then often says that subject to when this agreement is in place, at present, the contractor shall be entitled to a reasonable amount. Or it may say quantum merit, but it will then also quite often say that once the contract is put in place, it shall displace the letter of intent, which is again indicating to us fairly clearly that the letter of intent in itself is not the contract. Now, in my experience, letters of intent are issued for a number of reasons. Some of these reasons are poor ones. Now, with respect to a number of people who are listening, it is my experience that quite often letters of intent are issued by local authorities. And I know there are a number of people from local authorities who are listening. Now, the reason that they may be issuing these letters of intent is because, A, time. It takes a long time to get all the contract documents together and put together and issued. So we issue a letter of intent in the first place. It may be that we've got to get certain approvals in place or other factors. So that's one reason. Another reason is that there needs to be something obtained. So we've got time, we've got some form of approval, funding, for example, or it may be, for example, that there's a piece of land we haven't acquired yet. These are all reasons why letters of intent are issued. But as far as time is concerned, I would suggest that you should not be issuing a letter of intent where the only problem is time. As we've identified, all we need is a contract, is an offer and an acceptance, consideration and intention to create legal relations. So if you're a local authority, what I would suggest that you should be doing is you issue your invitation to tender and you say to the contractor that no tenders will be accepted that are non-compliant with the requirements of the letter of invitation to tender. So they price everything without amending it. You've now got your tender and your terms are, the tender is on the terms that you have requested. You can then simply respond saying, we accept. We'll forward the contract documents in due course for signature and sealing. But as soon as you say, we accept, you've got a contract. The fact that the contract has still to be signed is irrelevant. It does not present a problem. But where the issue is not time, but is other factors, then it is your decision whether you want to issue a letter of intent or rather a pre-contract service agreement, which indeed is one of the questions that was asked prior to the seminar. So which one should you do? Answer's a simple one. It depends. It depends which of these resultant effects you would prefer. If there is a letter of intent and it includes a cap, It states matters have still to be agreed and indicates the contractor is going to be entitled to quantum merit and that the contract will displace the letter of intent once signed, you are not in contract. You are instead in an area called quasi-contract and restitution. You have asked the contractor to carry out certain works, and in return, the contractor is entitled to a reasonable amount, quantum merit. Now, in view there is no contract, there can be no completion date. You can't have a completion date to something that is not a contract. There can be no completion, no provisions for liquidated damages, and no need for extensions of time either, because the contractor is entitled to quantum merit, doesn't need to claim loss and expense or otherwise. They're entitled to be paid a reasonable amount for the works they have been requested to undertake. What's more, they have, unless there is specific provisions, no commitment to complete the works. Now, this raises a number of situations. What happens where the letter of intent has a cap and a party exceeds the cap? So it says carry out the works up to £50,000, but because instructions keep being issued, the contractor carries on carrying out works over and above the letter of intent. Put simply, if the letter of intent says you're entitled to £50,000, you do £1 million worth of work, you're entitled to £50,000. Not a penny more. That's it. The only way you can get round it is if the employer, with the letter of intent in place saying we will not pay you £50,000 any more than £50,000, proceeds to pay £50,000 and 1 penny. By their option, they have indicated they are no longer bound by this restriction, and they will likely to be stopped from relying upon it. So very simply, where the letter of intent stipulates a cap, that cap is enforceable unless the other party, by their conduct, indicates they no longer want to be bound by it. So do be careful. If you exceed the letter of intent, you are not entitled to be paid beyond it. Equally, where you're under a letter of intent and for whatever reason you don't like those works, you can pull off. That's a worry as well. Now, I'm going to give you 2 cases which I was involved in, and they show you the significance of knowing whether you're in contract or not. The first one concerned the renovation of an area in central London where there was high contamination. Contractor had submitted what was several £1 million worth of a tender and had started on site. Having looked at the works, what they found was their estimator had woefully underpriced the element of contamination and its removal of, and which was seen as being a specific lump sum. They were losing a fortune. As is not unusual that where a party is losing money, they seek help. They're not interested whether they're right or wrong. They just want to get out of it. And I was called to site to have a look at the matter. And as is always the case, I started off by saying, can I have a look at the contract? He said, oh yes, we've got this, here it is. And I said, hold on, this isn't signed. Oh yeah, we haven't signed it yet. We're actually working under a letter of intent at the moment. Okay, very interesting. And how are you submitting your interim applications? Well, in accordance with our tender. And indeed, for those of you who are working under a letter of intent, I guarantee every one of you is submitting in accordance with your tender. That's not what the letter of intent says. It says you're entitled to be paid a reasonable amount. So you should be submitting your applications based upon a reasonable amount, which, provided you're doing the works reasonably, is your cost. Cost plus. Marvellous. So in this particular situation, I looked into the letter of intent and it was quite clearly not a contract. So I said to the contractor, it's very simple. This particular project, you've got no completion date, no liability to liquidated damages, all the decontamination, you don't need to stick with your price and you're entitled to a reasonable amount. But do be aware your invitation, your contract, your tender at the moment remains open. And as a consequence, the employer can accept it tomorrow. No surprise what we did. We withdrew our tender the following day, pointed out we're under a letter of intent and quantum merit, and to say the least, the employer wasn't very happy, nor were the professionals, the consultants team, who had to call upon their PI. Now I'm going to give you a second scenario. This is another case I was involved in. It was the construction of new offices on ground floor and very expensive flats above in central London, above a railway station, or at least a railway line, tube line. Now, for those of you who maybe have been involved in a project of that nature, you will be aware that you've got to have track monitoring in place. You've got to have a process where if there is any problem that affects the tube line, there's a monitoring system in place that gives warning and hence stops tubes. And that's what had in this particular contract. And what had happened was the whole obligation of getting this approved, this track monitoring, lay clearly with the contractor. Now, the contractor had been on site for a year, had a full crash deck in place and all scaffolding in place for a year, and had done no work. And they called me up to say, can we have an extension of time? We're losing money. We can't get the work started because we cannot get LUL's approval of our track monitoring system. Doesn't matter what we do, whenever we send it, they come back and reject it. What should we do? As is always the case, I asked the simple question, well, can I have a copy of the contract? And which they duly obliged and said, here it is, we signed it and returned it yesterday. And the simple situation was the day before, they were working under a letter of intent. The letter of intent was not a contract. They were entitled to quantum merit, no problems. But because they had, and which is not uncommon, simply signed and returned the contract once received, they were now bound by that contract. And having reviewed the contract, it was very well drafted. And it said the obligation for obtaining LUL's approval of track monitoring lay with the contractor, and hence the contractor had no entitlement to extension of time. In other words, the difference between the day probably cost them something like £7 or £8 million. They didn't need to send the contract. They knew they had problems and they ought not to have signed it. But the process is so common in construction. People think as a matter of course you should sign the contract, but quite often you shouldn't. But equally on the employer's side, quite often they think we'll send over a letter of intent because the other side will surely sign the contract sometime in the future. They might not. So in answer to the question, quite often I would suggest you are much better off to use a pre-contract service agreement and not a letter of intent. Okay, covered quite a lot there. Julie, are there any questions?
There are indeed. Quite a few, in fact. First question. So if you allow the subcontractor to start on site while they have provided a counteroffer, does this mean you have accepted their counteroffer?
Very simply, yes.
Okay.
Provided they've submitted a counteroffer by way of a revised quote, and that immediately thereafter, with no subsequent counteroffer in between, by you allowing them to start on site, you've accepted their offer. Yes.
Okay. There's two questions which relate to £1 being deemed unreasonable consideration. One
There's
person
no
asking,
such thing as unreasonable consideration. It's
right,
either consideration or not, and £1 is sufficient consideration. The law has said a peppercorn can be good consideration. For the ladies who are listening, I should tell you a quick case that's quite amusing and shows this situation. So what happened was a husband left his wife for a much younger woman. He was having a great time and decided that he needed some more money because he was spending it very quickly. So he contacted his wife, who's no longer with, and said, you know, I know this is a bit of a cheat, but, you know, would you do me a favour? Would you sell my car for me and send me all the proceeds? You'll find that all the deeds for the car are in the top drawer. Can you send it to me, sell it for me, and send me the proceeds? And the wife, looking back at the good days and everything else, says, yeah, of course, I'll help him out, even though he's run off with a younger woman. And indeed, she did sell his brand new car, and she sent him the proceeds, £1. She sold his car for her £1, and it was found to be binding because she was acting as his agent. He had given her the necessary authority, and she had sold it for good consideration. So it's binding.
There's a lesson in there. Someone else is saying that they often sign contracts with £1 consideration, but this consideration never passes from one party to the other, irrespective of whether consideration is adequate or not. What is the case if it never passes from one party to the other? Has a contract been formed?
Yes, generally it will be, because the consideration is the duty to pay. So when you enter into a contract on day one, the party A has an obligation to carry out the works, and party B has an obligation to pay for those works. But the contract's been put in place because of that obligation. So as far as the pound is concerned, there is an obligation to pay it. The fact they haven't paid it does not prevent the contract being formed, because the consideration is the obligation to pay the pound.
Okay. Someone else is asking, is it a sensible policy to only use PCSAs instead of LOIs?
That's the question I dealt with a little bit earlier. The answer to that is I would suggest yes, because if you enter into a pre-contract service agreement, it's a contract, it's clear. You set down what the party's obligations are. So where you're entering into an agreement for certain things that are uncertain, what I would certainly suggest is an enabling works contract. So let's go for an example. I've given advice recently on a project that involves the redevelopment of a listed building, changing it from what was a very large stately house into a hotel. Problem with that is, and those that have dealt with these sort of nature of problems, projects, is you never know what you're going to find. So rather than enter into a contract which is likely to be very uncertain, or issuing a letter of intent, what you would be better off doing is issuing an initial enabling contract for opening up areas. And then once having opened up areas, you then know what the scope of works will be and what the contract will be.
Okay.
So generally, you can do a letter of intent, but you are putting yourself at risk.
Okay, next question up is, what is the situation if the LOI incorporates the contract terms? Contract or terms just for the LOI work?
Okay, what you're looking for is, has everything been agreed? If you look at the letter of intent and any other documents that are incorporated, and you find that everything has been agreed, it's a contract. A letter of intent where it is not a contract is because something has not been agreed. But if it's, for example, limits the price, the fact that contract is in there, but there is a cap on the scope or a cap on time, then there's a problem because you haven't agreed everything. The contractor cannot complete everything, so you haven't reached agreement.
Okay. Someone else is asking, if the owner gives an oral command to start work at site, should this be considered as an acceptance, or should he send it written? And if this person concerned, if they'd started, does the project time start to count?
Okay. There is no difficulty of proceeding following an oral request than a written request, other than proving it. Because you got the oral request, and you say, he asked me to start, and then surprisingly, 6 months down the line, he says, oh no, I didn't. It's like the pantomime time again. So it's always easier to prove something if it's in writing. So ideally, you want the other party to write to you to confirm to start, or alternatively, simply say, I confirm your phone call this morning, requesting me to start tomorrow. You've got it recorded. You then start, even though silence is never acceptance, and therefore their failure to respond doesn't mean they've accepted. But the question is they have allowed you to start and you've recorded that it was upon their request. It's going to be difficult for them to prove otherwise. What was the latter part of that question, Julie? Because I've asked you that.
If the person concerned has started, does the project time start to count?
Well, project start time to start, it will only start if there's been a full agreement and which includes a completion date. So it may be the case that asking you to start, what you've got to look at was there previously an offer? What was that offer? Has it been accepted? And has that contract got a completion date to it? And the answer to all of those is yes, then you have no problem, or a problem, depending on which side you're looking.
Okay. Last question that's been flagged up here. Knowing that we're still in an ongoing pandemic, do you believe that implications similar to COVID or any other global catastrophe within contracts and their force majeure clauses favours a contractor over the clients as extension of time or any compensation specifically towards the contractor rather than this event being unreasonable on all parties? How can we achieve the implied fairness?
No one said contracts would be fair. And no one said there is no implied term of fairness. No contract is meant to be fair. The parties have reached an agreement, be it good or bad. There are certain provisions that look to protect people. For example, the Unfair Contract Terms Act. But if you look at that act, it doesn't say you can't have unfair terms. What it does is apply to exclusion clauses, limitation clauses, and otherwise. But it does not say you cannot have an unfair term. So it is down to you as to whether you've reached an agreement. Now, let's just deal with a couple of points. The first thing is, quite often, I get involved in a dispute and party A says, I think we've agreed this. And party B says, I think I've agreed this. And I say, well, sorry, you're both wrong. Because it is not what the parties believe they've agreed. It is what the reasonable person on the Clapham Omnibus or on the London Underground now looks at the documents alone and says, I think that's what you've agreed. And if that's what's agreed, be it good or bad, that is what you are bound to. Okay, now there may be reasons why those terms are unenforceable, unclear, uncertain, or contrary to a statute, but generally what you've agreed is what you've agreed. Now, let's turn to COVID. Force majeure, act of God, something that the parties were unaware of. Well, we are aware of it. So the force majeure clause is only likely to apply to contracts entered into pre-knowledge of the coronavirus. If you now enter into a contract, it is unlikely that the force majeure clause will apply. So going forward, if you are a contractor and you want to ensure that you are not responsible for delay caused by coronavirus or any other virus of past, which is reasonably known of in the past, it's very simple. Get a clause in there written saying it. Do not rely simply on a force majeure clause because it is unlikely to work going forward.
Okay. Another question here. What needs to go into a pre-contract service agreement to make it binding?
Offer and an acceptance.
Okay.
The answer is very simple, is what, whoever asked the question, let's put you in as the judge. And the two parties are seeking to argue lots of different things, and you've got to decide. What you're going to have to look at is, what does that service agreement provide? And do I understand it? So the first thing it must set down is what the hell one party is to do. And provided you've got that, then most of the other things can be complied with. So you are to do X. What are you going to be paid? Doesn't say. Reasonable amount. How long have you got? Doesn't say. Reasonable period of time. No problem. But if it doesn't say what you're going to do, you've got no hope. So the most important thing is it must set down clearly the scope of the works. Then ideally, if you do not want reasonableness and implied terms coming in, you want to stipulate time, payment and other provisions. The more details you put in, the more certain it will become. Now, if we look at the JCT suite of contracts, have a look at the minor works and have a look at the design and build version. And what's the difference? Very simple. One's very heavy and got lots of pages and one hasn't. Why is that? Because the minor works deals with far less. It's not expected to be a complicated project, and hence it doesn't have as many provisions. The design and build has much more provisions. So depending upon how much control you want, that will then dictate how much information you need to put in the PCSA.
Okay, that appears to wrap up our questions for this evening. Thank you very much, Richard. As we said earlier, if anyone wants to contact you directly, it's Richard Silver at silverllp.com. Happy to answer any and all questions that you receive. And then I believe the next one is next month for the next construction essentials in the new series that you're doing. So thank you very much.
Just a couple of things just to add. If you found the course useful, I would appreciate for you to put a like against it on LinkedIn. If you thought it wasn't very good, please keep your thoughts to yourself. As far as the nature of questions that you've put to me, hopefully you've seen that I've been able to answer them very quickly and hopefully succinctly. We have a helpline where you can either email in or call and ask a particular question. Someone is likely to call you back. The likelihood is it will be me, and then I will give you the answer to your question. Of course, you all know what the answer to the question will now be. It depends upon what the contract says. But generally, I can tell you what the standard forms say and also identify where within them you should be looking for any amendments. The other thing is that hopefully you've found this course useful, and there are 9 more. But if anybody is interested in a bespoke online seminar of this nature to meet their particular requirements, then we're happy to provide same, and please do contact Julie.
Okay, thank you very much. Thank you very much, everyone, for attending. It's nice to see everyone back again in January for the new year, and we will see you all again soon. Thank you very much, Richard.
Thank you.
Thanks. Right, thank you, Richard.